the Children, Guardianship and Custody Act. Remember now, I'm not an attorney, but what I want us to do is read through these acts together, acts like this. July, 1st of July, 1957. But of course, there were some amendments, updates, and so on. For example, in 1956, 69, 75, 79, 91, up to, well, the latest here that I have was in 2011. The latest adjustment to it. Alright, Section 1, short title. This act may be cited as the Children, Guardianship and Custody Act. Section 2, interpretation. Subsection 1, in this act, unless the context otherwise requires, court means A, the Supreme Court, or B, where the respondent or any of the respondents or the applicant or the child to whom the application relates resides in the parish of Kingston or the parish of St. Andrew, the family court, corporate area, region, as respects any time on or after the 13th day of November, 1978, or C, where the respondent or any of the respondents or the applicant or the child to whom the application relates resides within the geographical jurisdiction of a family court established pursuant to Part 2 of the Judicial Family Court Act, and that family court as respect any time on or after the date of establishment of such court, or D, where the respondent or any of the respondents or the applicant or the child to whom the application relates resides in a parish other than those specified at B and C. It is the resident magistrate court. Child means a person under 18 years of age, but does not include a person who is or has been married. So it suggests that one can marry before the age of 18. And if that is the case, that person would not be considered a child. A 17-year-old who is married is not considered a child based on this act. Alright. Well, for the purposes of the law, they're not considered, that person would not be considered a child. That seems to be what it is saying. Now, resident magistrate means A, in reference to a resident magistrate for the parish of Kingston or the parish of St. Andrew, a judge of the family court, corporate area, region, and in reference to a resident magistrate for any parish within the geographical jurisdiction of a family court established pursuant to Part 2 of the Judicial or Family Court Act. It is a judge of that family court. Alright. So, those are resident magistrates. Here, rights of surviving parent as to guardianship. Section 3, subsection 1. On the death of the father of a child, the mother, if surviving, shall, subject to the provisions of this act, be the guardian of the child, either alone or jointly with any guardian appointed by the father, When no guardian has been appointed by the father, or if the guardian or guardians appointed by the father is or are dead, or refuse to act, the court may, if it thinks fit, appoint a guardian to act jointly with the mother. 2. On the death of the mother of a child, the father, if surviving, shall, subject to the provisions of this act, be guardian of the child, either alone or jointly with any guardian appointed by the mother. When no guardian has been appointed by the mother, or if the guardian or guardians appointed by the mother is or are dead, or refuse to act, the court may, if it thinks fit, appoint a guardian to act jointly with the father. Power of father, section 4. Power of father and mother to appoint testamentary guardian. Subsection 1. The father of a child may by deed or will appoint any person to be guardian of the child after his death. 2. The mother of a child may by deed or will appoint any person to be guardian of the child after her death. 3. Any guardian so appointed shall be jointly with the mother or father, as the case may be, of the child, so long as the mother or father remains alive, unless the mother or father objects to his so acting. Subsection 4. If the mother or father so objects, or if the guardian so appointed as aforesaid considers that the mother or father is unfit to have the custody of the child, the guardian may apply to the court, and the court may either refuse to make any order, in which case the mother or father shall remain sole guardian, or make an order so that the guardian so appointed shall act jointly with the mother or father, or that he shall be sole guardian of the child, and in the latter case may make such order regarding the custody of the child and the right of access thereto of its mother or father, as, having regard to the welfare of the child, the court may think fit, and may further order that the mother or father shall pay to the guardian towards the maintenance of the child such weekly or other periodical sum as, having regard to the means of the mother or father, the court may consider reasonable. So they seem to be saying that a mother or father, before their death, may appoint a guardian. However, if the parent who is still alive considers that the guardian is not fit, they may apply to the court. Or if the guardian considers the mother or father not fit, they may apply to the court. and whoever is guardian, they would receive child support maintenance ordered by the court. All right. Subsection 5 of section 4. Where guardians are appointed by both parents, the guardians so appointed shall, after the death of the surviving parent, act jointly. All right. The guardians so appointed. If under section 3 a guardian has been appointed by the court to act jointly with the surviving parent, he shall continue to act as guardian after the death of the surviving parent. But if the surviving parent has appointed a guardian, the guardian appointed by the court shall act jointly with the guardian appointed by the surviving parent. All right. Section 5. Powers of guardians. Every guardian under section 3 and 4 shall have all such powers over the estate of the person or over the estate as the case may be of a child as a guardian appointed by will or otherwise has in England. Remember, this is Jamaican law though, but you may borrow some ideas from England. Section 6. Equal right of mother to apply to court. The mother of a child shall have the like powers to apply to the court in respect of any matter affecting the child as are possessed by the father. Section 7. We will stop here and look at section 7 in another video.